to our webinar on practical employment law tips for employers. This is the first in a series of webinars that the Labor and Employment and Human Resources Practice Group at the Wagner Law Group will be offering. This presentation will last about 30 minutes, and the slides from the webinar will be available on the Wagner Law Group website. Let me introduce David Gabor, of counsel with the Wagner Law Group. David is a recognized leader in the employment law field. He represents clients in litigation, the negotiation and drafting of contracts, handling compliance issues, the creation of corporate infrastructure, the drafting of policies, training of employees, and leading company towards organizational excellence. Welcome, David.
Thank you, Barbara. Good day to you, and thank you for joining in the first of what I hope will be a series of webinars regarding employment law and HR. The employment law field is so fluid. There are constant changes, new laws, landmark cases, economic factors, and new challenges that all have a profound impact on the employer-employee relationship. Sir Francis Bacon was right. Knowledge is power. The employer-employee relationship can and must be managed. To do so requires knowledge of the law, awareness of potential issues, the ability to anticipate problems, and the wherewithal to resolve them. The plan for today's program. We're going to explore recent trends in employment law, and we're going to do that by looking at the annual report from the Equal Employment Opportunity Commission. We're going to learn from 3 Supreme Court cases that are landmark cases in the field. We're going to discuss practical tips for protecting employers, and we're going to create some viable strategy. And last but not least, as a teacher for the day, I have a right to hand out homework assignments, and I will give you a homework assignment at the end of the program. The Equal Employment Opportunity Commission maintains that in 2011, a record 99,947 charges were filed. $456,600,000 was recovered from employers by the EEOC. 112,499 charges were resolved, and from 2001 to 2011, the number of charges filed with the EEOC increased by approximately 20%. Now, these numbers do not take into consideration cases that are filed directly in court or cases that are settled in claim only. The EEOC's report indicated that 37.4% of the charges filed included a claim of retaliation. So we're going to spend a lot of time today talking about retaliation. 35.4% of the charges filed involved claims of race discrimination, and that number has been high for a long time. Significantly, there's been a dramatic increase in the number of charges filed under the Americans with Disabilities Act, and also approximately 10% of the charges filed with the EEOC were resolved through mediation. And that's something that I wanted to talk about a bit, because most of the times mediation at the EEOC happens very early in the process, so it stands to reason that many of those charges filed with the EEOC that are settled in mediation could have been resolved before a charge was ever filed with the EEOC. And we're going to talk about that a bit as well. What the report means to you as employers is that we're not doing a good enough job heading off claims of retaliation. Now, put yourself in the shoes of an employee who complains for a moment and think about the things that happen to employees that could give rise to a complaint of retaliation, and try to avoid those sorts of things, such as, for example, a change in terms and conditions of employment, a cold shoulder, putting a person on a graveyard shift, micromanaging an employee. Those are the things that employers sometimes do, or employees perceive are being done to them, that lead to claims of retaliation. The second thing is, it's very important, since there's been an upswing in the ADA complaints, to make sure that the supervisors and managers are being trained on ADA and leave issues. Communication is something that oftentimes is a point of discussion in cases filed in court or with the EEOC. Employees complain that they don't feel like there's a good and viable means for communicating with HR, with supervisors, with senior management. If in the company it's possible to make the employee feel empowered, valued, an important part of the team, that employee is less likely to file a complaint. Finally, it's important to get managers to make HR aware of issues or potential issues promptly. All too often, HR finds out about a problem after the problem has gone from a small, minor issue to a full, raging fire. Now, there are three decisions from the Supreme Court that we're going to talk about today. The first one is the Thompson versus North American Stainless case. This is a case involving retaliation and an expansion of the concept of dissuade, which we're going to talk about as the first case. The second case is Kasten versus St. Gobain Performance Plastic Corporation. And this is a case that was filed under the Fair Labor Standards Act and talks about when an employee has protection against retaliation if they file a claim under the FLSA. Finally, we're going to talk about Staub versus Proctor Hospital. And this is a case where the decision to terminate Staub was not made by a person who had any kind of discriminatory animus, but rather by a person from the HR office. Discriminatory animus is when a person's actions are motivated by something that's unlawful, such as, for example, race, gender, religion, ethnicity, or national origin, the 5 protected groups under Title VII, the ADA, Americans with Disability Act, or the Age Discrimination and Employment Act, the ADEA. So let's talk about the Thompson case. Eric Thompson and Miriam Rigolato are engaged. Rigolato made a complaint of sexual harassment with the Equal Employment Opportunity Commission. It so happens that Thompson and Rigolato both work for North American Stainless. 3 weeks after North American Stainless finds out about Rigolato's complaint, what do? They fire Thompson. So Thompson brings a case of retaliation against North American Stainless. At this point in time, cases of retaliation have not been recognized when the person who brings the complaint has not made a claim or engaged in a protected activity, which we're going to talk about on the very next slide. Thompson's position before the Supreme Court is, number one, Thompson's position before the Supreme Court is that the decision to terminate him was retaliation and revenge for Rigolato's complaint. North American Stainless' position is, one, Thompson doesn't have standing because he never complained. Two, that if you expand the protection for retaliation to include Thompson, the fiancé, do you also include any other family members, friends, colleagues, and everyone else in the company? Basically, North American said that if one person complains, we don't want a situation where every single person in the company or a substantial number of the people in the company could also be protected from claims of retaliation. What the Supreme Court did is they went back to a decision that was rendered in 2006, Burlington Northern Santa Fe Railway against White, where they talked about the concept that the retaliation laws are there to prevent employers from engaging in an activity which would dissuade an employee from complaining. And the termination of Rigolato's fiancé would have dissuaded Rigolato from complaining in the first case had she known that the company would fire her fiancé, and that therefore Thompson could maintain the claim of retaliation against North American Stainless. So this is a good segue to talk about retaliation. Retaliation occurs when an employee opposes discrimination. This can be done by making an internal complaint within the company, going to a supervisor, a manager, HR, or a senior executive in a company, among other sources. A complaint filed with the Equal Employment Opportunity Commission or a state or local anti-discrimination agency, or a case that's filed in court. Any one of these three avenues is considered a protected activity. The employer needs to be aware that the employee has opposed discrimination. Then the employee suffers some form of an adverse employment action. And there's a causal link between the opposition and the adverse employment action. Now, it's very important that you understand that an employee does not need to be right when they complain about discrimination in order to be protected under the law, so long as the employee reasonably believed that he or she was the victim of or was aware of some form of discrimination in the workplace. So an employee could sue, for example, that they were terminated because of race and then also retaliation. And they could be wrong about the race and still win under the retaliation. So even if the employee's complaint doesn't really make a whole lot of sense, the employee may very well be protected under the retaliation statutes. So now we have a holding from the Supreme Court that says that we've expanded the protection under the doctrine of dissuade to include a fiancé. What the court did not do, what the court did not indicate whether the expansion would also include other relatives, close friends, or coworkers. Many companies have nepotism where we have one family member who works for the organization and several other family members also work for the organization. So the courts left unclear what other employees might fall under the umbrella of protection, which now creates some pretty significant challenges. What do? You've got a person who's complained, and now you have to think about whether a family member, a close friend, a coworker also is going to fall under the umbrella of protection on the anti-retaliation laws. And it seems to me that the best thing to do is to make sure that first things first, when the complaint comes in, it's got to get to HR and it's got to get to senior management of the company. And at that point, it's best to create a strategy of what to do in this particular case. How do we protect the company, avoid a claim of retaliation, and maintain morale and productivity? And at the same time, we're aware of the fact that other employees who may fall under that umbrella of protection might be privy to confidential information, might have access to witnesses who could bear heavily in the original complaint. So on a case-by-case basis, this is something that's going to have to be talked about. One of the other things that would be really helpful would be to make sure that we've got in place a strong and viable communication system. Because the mere fact that an employee has complained does not necessarily mean that the employee is now an enemy of the company. And it may be that the employee's issue is an issue that can be resolved through strong lines of communication. And that oftentimes is the best way to solve these kinds of concerns. Now let's talk about the Kasten case with St. Gobain Performance Plastics Corporation. Kasten objected to the employer's pay policies. What happened is Kasten would go to work, he'd park in the parking lot, he'd walk down a long hallway, he'd go in the locker room, he'd have to change out of street clothes into uniform with protective clothing, and then walk down another hallway, punch in at the time clock, and go to work. And Kasten objected to this because of the fact that the time it took him to walk down the hallway and change and then walk further down the hallway and punch in would deprive him of an hour to an hour and a half a week that he should get paid for. So he made verbal complaints to HR and to managers inside the company. Then Kasten was fired. Believe it or not, he was fired because the company said he was not following the company's time clock policy. Kasten claims he's fired because of his complaints. The employer maintained that verbal complaints are not protected under the Fair Labor Standards Act, the FLSA, which calls for protection where the employee has filed a complaint. So the case went to the United States Supreme Court. Now, the FLSA was enacted back in 1938, which was in the height of the Depression. At that time, a significant portion of the working population in the country was illiterate. The Supreme Court reasoned that Congress would not have enacted a statute that would not protect a significant portion of the workforce, so that Congress would have intended for verbal complaints to be protected under the FLSA as well as written complaints. Also, the Supreme Court recognized things such as a scenario where a person calls a hotline to make a complaint. Obviously, a phone call would not be a written complaint. Similarly, when people sit down with someone at the Department of Labor and the person at the Department of Labor is taking notes, that's not a written complaint. And the same should be true if you meet with someone in HR in the company. Those complaints should also be protected. So what do we learn from Kasten? We learn that whenever an employee makes a complaint, verbal or written, to a manager, whether it's not that person is a direct manager of the employee or a supervisor, it's so critical that these complaints are brought to the attention of HR as quickly as possible. One other important note on this particular topic is that an employee may come in with a wage and hour complaint, or a race, or an age, or whatever the issue is. And as a single employee bringing something to the attention of the company, if the company handles it properly, the issue can be resolved without litigation, without counsel fees, and without adverse publicity. If the issue is ignored or improperly handled, this may end up being a class action lawsuit where 10, 15, 20, 100, 500 employees now become part of a class in a major case. And don't think the EEOC would not be interested in those large cases, because the EEOC takes pride in the amount of money they're able to recover from companies, and they love to publish these things on their website in their press releases. So oftentimes, direct results are so important. Now let's talk about the Staub case against Proctor Hospital. Vincent Staub was a member of the United States Army Reserves, and as a member of the Army Reserves, he was responsible on a periodic basis to attend to military activity. And his supervisor, Janice Mullally, and Janice's supervisor, Michael Karenchuk, did not like that Staub was taking the time off. So they went to HR and complained about Staub. They talked to other people who were in the same department as Staub, and they were making a big stink about how Staub was the employee from hell. But, and their complaints to HR went to a person named Linda Buck. Now, Staub knew that he was being targeted, so he also filed a grievance about how he was being treated. HR fires Staub based solely on the complaints made by the supervisor. Buck had no direct knowledge of whether or not Staub was or was not doing the things complained of. And Buck also did not have any discriminatory animus towards Staub. Buck missed the opportunities. She did not pick up on any of the warning signs that existed. For example, in this particular case, at one point it was decided that Staub should be put on a PIP, a performance improvement plan. However, even though the PIP was prepared, it was never given to Staub and it was never implemented. Staub had filed that grievance. And also, if Buck had talked to any of people in the department, she would have found out that the supervisor, Mullally, was trying to get people to make false statements about Staub. So the Supreme Court held that the company was liable for the wrongful termination of Staub, even though the supervisor, Buck, did not possess discriminatory animus. She had no feelings one way or another about Staub because of his military duty. However, the company was still liable because the people who did complain about Staub set about the wheels in motion with a desire of getting rid of him because they did not like the fact that he was not at work as much as they wanted. Essentially, in this case, the buck stops here. Ha, ha, ha. Now, the Supreme Court also likened this case to a cat's paw, which is an Aesop's fable, where a monkey wants chestnuts that are roasted in a fire, and there's a cat sitting by the fire. So the monkey charms its sweet talks the cat into sticking its paws into the fire to remove the chestnuts. And the cat does just that. The monkey takes the chestnuts and takes off, leaving the cat with nothing but burnt paws. In this case, the supervisors wanted to get rid of Staub. They gave information to HR, so HR would do the dirty work, and that's just what happened. So what do we learn from this? We learn that HR needs to look for red flags. And prior to making a decision to terminate somebody, some of the things that HR can look for would be prior complaints by the employee in question, prior complaints about the supervisor who wants the employee to be disciplined, and also look for a paper trail. Have there been written warnings, verbal counseling? How was the last performance review? Look at these things prior to making the decision to terminate somebody. For these things that constitute a paper trail are exactly what the EEOC would look at, and that's the first thing what a judge will ask for at the initial conference of the case. What kind of paper trail is there? If there's the slightest hint of an concern, then some modicum of an investigation needs to be conducted. Depending upon the extent of the alarm or the concern, you may have a more in-depth investigation or not as in-depth an investigation. And by the way, cat's paw cases are not uncommon. Now, the next area we wanted to talk about are arrest and conviction records. The EEOC has targeted employers who have overly broad policies about hiring people with arrest or conviction records. And this is a particularly challenging issue because on the one hand, employers want the best candidate for the job. Skills, education, training, experience are important, as is culture. We want employees who fit the corporate culture of this company. And it's doubtful that very many of you have a corporate culture akin to cell block C. At the same time, there's a public policy crying out for getting people who have done their time back to work. We can imagine that if no person who has served time can get back to work, some of them may go back to committing crimes in the future. We want them back to work. So we're balancing those two issues. Now, the EEOC issued a guidance in late April this year, and some of these numbers scare the tar out of me. 1.8% of the adult population in 1991 was going to have some involvement with what they called correctional control. And that number increased to 2.7% in 2001, a decade later. And 6 years later, in 2007, 3.2%. Now for the numbers that really scare me. 1 out of 17 white men will serve time in prison. 1 out of 6 Hispanic men will serve time in prison, and 1 out of 3 African American men will serve time. Based upon these figures, the EEOC has concluded that any blanket policy that people with a criminal record will not be hired will have a disparate impact on African American and Hispanic candidates. A disparate impact case is a case where a company has a policy that is facially neutral, meaning that it's not targeted against any protected category such as race, religion, gender, age, disability, ethnicity, or national origin. However, even though the policy is facially neutral, the impact to that protected class can be more significant than it is for others. And that's what a disparate impact case is. A disparate treatment case, on the other hand, is a case where the company's policy varies from one person to another. An example of a disparate treatment case would be 2 people apply for the same job. They both just graduated from the same college. They both had the same major, same grade point, grew up in the same neighborhood. Both of them are the same age. Both of them were arrested and convicted for the same crime at the same time when they were years younger. And let's say the crime is possession of marijuana. And the company says, we're not going to hire one of them who happens to be African American because we can't have any drug dealers running around here. We can't have any potheads. And the other person, who happens to be white, they say, oh, we're going to hire him. That's okay because that offense happened 5 years ago. That's a classic example of a disparate treatment case. Now, another thing that's important is that where a person applies for a job has been arrested but not convicted, that can factor in the decision to hire or continue employment. The fact that the person was arrested is not what the employment decision is based on, but the underlying grounds or conduct for the arrest can be considered. An example would be an assistant principal in a school is accused of touching a female student. The assistant principal is arrested, and now the school's got to decide what to do with this assistant principal during the time that the criminal case is going on. And the best thing to do is to conduct an investigation, interview the student involved, interview other students who may have been witnesses, interview students about whether they feel that they were inappropriately treated or touched by the assistant principal, interview faculty members, and interview the assistant principal. And then based upon those interviews, decide what you're going to do. What the EEOC has encouraged employers to do is to focus on the nature or the gravity of the offense. The time that has passed from when the person was convicted of a crime to present, and the nature of the job held or sought by that employee. Now, there are times where an employer is within its rights to refuse to hire someone because of a criminal conviction. A couple of examples. This is not an exclusive list. The airport has security screeners, and under federal law, a person who's been convicted of a crime cannot be a security screener, and I believe it's a 10-year period. People who are working in positions involving child care. People with security clearance requirements for a job, such as, for example, someone who's a purchasing officer working for a government contractor, a banker, a person in a fiduciary position. It's within your right to preclude employment based upon people applying for positions such as those positions who've got criminal records. One case that was resolved through the EEOC, and it was published in January of this year that I wanted to mention, involves Pepsi-Cola. Now, for those of you who don't know me personally, I'm a very large consumer of the Pepsi industry. I'm a fan of the Diet Mountain Dew product, and I was very upset when I saw this decision. Pepsi has a policy, or I should say had a policy, that job applicants who have been arrested pending prosecution were not hired for permanent positions, even if they were never convicted of an offense. The EEOC said that's a disparate impact case, based upon the reasons we talked about a few minutes ago. And Pepsi had to pay $3.13 million in that case. What do we learn from it? Again, a facial neutral policy that is overbroad can be unlawful. Whether or not you agree with the position taken by the EEOC regarding hiring people with criminal records, you have to make sure that your policies are facially neutral. Now, the EEOC has recommendations regarding what employers can do. Eliminate policies or practices that exclude people from employment based on criminal records. Develop a narrowly tailored written policy and procedure for screening applicants. Identify essential job requirements and the actual circumstances under which the jobs are performed. Dependent upon the position, it may be acceptable to have a harsher policy. Determine the specific offenses that may demonstrate unfitness for performing such jobs. Identify the criminal offense. Look at the duration of exclusion for criminal conduct based upon all available evidence. And then basically, in a nutshell, speak with the candidate, do some form of investigation, make notes, make records, and hold on to those records to show that you don't have a blanket policy, but it's a policy that varies dependent upon the circumstances. Here are some tips to take away from the program today. The goal is to be able to identify and mitigate risk without unduly burdening the company. I know that people in HR have a ton of work on their plate. I know that companies cannot have an overly broad policy of investigation and that time is money and time management is critical. The way to work with it is just make sure the managers and supervisors are working closely with HR, that there is a good line of communication flowing both ways. Watch out for retaliation. It's a hot issue. Look for those red flags before making employment decisions, and be careful about disparate impact in the criminal case. Now, here's that to-do list, which is the homework I promised I was going to give you. Look at your policy manuals, make sure they're current. Confirm that your managers and supervisors are trained on harassment, but also, in addition, on leave laws and in reporting to HR. Make sure HR is in the loop. Review how complaints are being handled in your company, and stress communication as much as humanly possible. If you do all these things, you follow these procedures, I'm really hoping that you're going to be able to sleep at night like a little baby. Thank you so much for attending the program today, and I look forward to putting on future programs for you on issues such as the leave laws, such as harassment, the National Labor Relations Board, and several other issues. Thank you again, and have a wonderful day.